Hello, it is now 6:31 p.m. and I am going to call the meeting to order. The Stratford Planning Commission is now open for a public hearing for those petitions advertised to be heard at this session. Regular members present at this meeting are Steve Rowe, if you could say hi. Joe Garrix.
Here.
Claire Barber. And then seating as an alternate for Alec Vacola is Ed Kingston.
Here.
And we are joined by our town planning and zoning administrator, Sismitha Tata, and our town planner, Stephanie Camp. And then Mio for our recording secretary. Before calling for the first petition, I'd like to inform those of you who have never appeared before us that it is the policy of this commission to have questions of the petitioner directed through the chairman. By the way, I'm Sarah Graham. Sorry, normally that's here. The chair reserves the right to rule on cross-examination for the purpose of clarification of technical questions. I wish to announce that should any items on tonight's agenda take more time than anticipated, the public hearing may conclude at 11 p.m. and be continued to another date which will be established at that time. Any items not heard by 11 p.m. tonight will be heard at the continued public hearing. For the record, petitions to be heard this evening were advertised in the Town Planning and Zoning webpage and in the Town Clerk's office in accordance with the state statutes. I will now advise the, if you could, the town planner, if you could read the first petition, which is 75 Pumpkin Ground Road.
75 Pumpkin Ground Road, continued from the October 21, 2025 meeting. Petition of Michael Sorockman III to re-subdivide 75 Pumpkin Ground Road property into two lots with lot sizes of 0.51 acres and 0.3 acres, respectively, in a RS3 zone.
Thank you. And the petitioner is present? Okay. Please announce your name and address. And for the record, this petition was advertised in the Connecticut Post on November 4th, 2025 and November 14th of 2025. The petitioner has also posted a sign on the property and is now requested to submit your certificates of mailing to the abutters in case you haven't provided those already. So if you would please introduce yourself and present your case.
Thank you, Madam Chair. And just for the record, my name is Thomas Lynch. I'm an attorney with the firm of Lynch, Trimbicky, and Boynton. And my office is located in Milford at 63 Cherry Street. And
angle it up a little bit.
Okay.
Just angle it a little bit. Thank you.
So I do have the mailing certificates to be submitted. So this matter was continued from last month's meeting. I don't know if the board members have questions, but just to refresh everybody's memory, this is a two-lot re-subdivision of the property of 75 Pumpkin Ground Road. The plans were submitted to you, engineered by Codispodi and Associates of Orange. The plan is for a division of the existing parcel into two almost identically sized lots, both far in excess of the minimum square footage requirements in the town's RS3 zone, which is 10,000 square feet as a minimum. Each of these lots, one lot is 0.51 acres, and the other one is 0.3 acres. There's clear sight lines. Driveways do come out to Oak Ridge. The plan shows that there is a sidewalk on the adjacent, this is being a corner lot, there's a sidewalk on Pumpkin Ground Road that terminates basically some 200 feet or so from the intersection with Oak Ridge. My client did have a discussion after the last public hearing with John Casey, the town engineer. We had submitted a request for a waiver of sidewalks, But after the discussion with Mr. Casey, my client is willing to put an additional extension of the existing sidewalk on Pumpkin Ground up to the intersection with Oak Ridge. We're still asking for a waiver of the sidewalk on Oak Ridge insofar as there are no other parcels on Oak Ridge that have sidewalks currently, but in good faith, the existing sidewalk on Pumpkin Ground, we, as a condition of approval, would be extending that up to the intersection with Oak Ridge. But other than that, this is a pretty straightforward application. It meets all of the standards of Section 8-25 of our zoning, of our state statutes. It meets your plan of conservation and development. It's envisioning a division of this property into 2 single-family residential lots, which is in conformity with the zone. So if there's any further questions, I know it was continued. There were some comments that I had read the minutes of from some of the neighbors, but clearly there's no public health or safety adverse effect from the division of this parcel into 2 lots, and we'd ask that you approve it. Thank you.
Thank you. Now will the town planner please summarize your staff report to know if the proposal is consistent or inconsistent with the POCD?
So the staff report we have is the same as our last meeting. I can summarize it again if you would like. So the petitioner is proposing to re-subdivide the subject property into 2 residential lots to build a single-family home on a new lot, as he just mentioned. The subject property is located in a residential single-family RS3 zone. There is 1 single-family home on this lot currently with frontage on Oak Ridge Road. The total area of the parcel is 0.83 acres approximately. The minimum required lot area for a lot in an RS3 zone is 10,000 square feet. With the proposed split, 2 zoning compliant lots of 0.51 acres and 0.32 acres each would be created. The portion of the lot that is vacant right now is well maintained and has a few trees on it. The site has an elevation difference of roughly 20 feet from east to west, and it is roughly 250 feet away from a 100-year floodplain to the east. There were a few comments from staff for the last meeting. The town engineer provided comments. He said the applicant provided a single site plan only, and there are no drainage calculations or drainage facilities shown on the plan. In an email dated October 3rd, 2023, the town engineer states that there are no drainage calculations or facilities shown on the plan. He requested that drainage calculations be submitted in facilities designed to show no net increase in runoff in the peak rate of flow from the site and storage of 1.3 inch of rainfall permanently on site. This is to ensure that there is no increase in directly connected impervious areas from the proposed development. He also offered additional comments. The consideration should be made for the sidewalk on Pumpkin Ground Road to be extended to Oak Ridge Road with a compliant ADA curb ramp at the intersection. Additional street trees should be provided in front of Parcel A in accordance with the tree warden requirements. A street line monument should be set at the intersection of Pumpkin Ground Road and Oak Ridge Road. The house numbering will change for both the new house and the existing house, with the existing house having an Oak Ridge Road address. It should be clarified whether the front door would be located on the proposed house to determine which street address the new house would have. This can be coordinated at the time of building permit. Sewer connection charges would be required for the additional lot at the time of the building permit application. At the time, there were no comments provided by the assistant fire chief or the police chief, and that has not changed. The conservation superintendent, in an email dated September 17th, 2025, that regarding the trees proximal to the new curb cut for the new driveway, the applicant needs to incorporate tree protection into their plans to be installed prior to the beginning of construction. However, there is at least 1 tree that is listed in poor condition in our tree inventory. This will be inspected once a proposal advances to construction to ensure that these trees will remain. The applicant should also consider compliance with our MS4 permit for effective stormwater management. As discussed, there were waivers requested. As far as consistency with the plan of conservation and development, the future land use map in the POCD recommends medium density residential land uses for this parcel. Medium density residential areas incorporate predominantly single-family homes in addition to some multifamily structures that promote diverse housing options. These generally have 2 to 4 dwelling acres per unit. this proposal to re-subdivide the subject lot to accommodate 2 single-family homes on 2 separate lots. Thus, it is consistent with the future land use map recommendations of the POCD, and it also meets the following housing objective of the POCD, which is Objective 3, enable more housing choices and options than what exists currently and to address current and future housing needs. We did have an additional staff comment from the health department after what was requested at the last meeting. I can read that for the public to hear. Okay. So the Stratford Health Department on November 5th sent in some comments. While the current application does not include a development proposal, they note it's important to note that a small number of nearby properties are currently served by private drinking water wells. There are potential impacts to these wells depending on the development activities. Where any significant earth removal and or blasting activities are to occur, there is concern for possible negative impacts to the quality and quantity of water in neighboring drinking water wells, as well as other environmental factors, such as erosion, sedimentation, and decreased surface water conditions. They recommend that in case there is significant earth removal or blasting when a site is developed, that the developer should retain a geologist or hydrologist and a licensed environmental professional. Prior to any active earthwork or blasting, the developer's licensed environmental professional should identify all drinking water wells within a 500-foot radius. The Stratford Health Department has also been made aware of the concerns over potential vibration that may be associated with future site development, which was expressed in the last public hearing. The Stratford Health Department does not have direct purview over vibration associated with construction and site development conducted during daytime work hours. However, all blasting plans require review by the town fire marshal. In addition, any future developer will be subject to the hours outlined in the noise ordinance of the town of Stratford. So that was the gist of the Stratford Health Department's comments.
Thank you. I can now request that fellow commission members to ask the petitioner any questions they have on the application. Does anybody have questions or discussion with him? Go ahead, Joe.
Will the proposed developments have basements?
Yes. One single-family house with basements, yes.
Anybody else? Okay.
Chair?
Yep.
We also received a letter to be entered into the record by a resident, and Stephanie gave you copies of that. It's from Dave and Liz Crosby of 125 Pumpkin Ground Road. I'm just stating it for the record so that you all acknowledge this. So she's concerned about the property having all ledge and blasting that will be required, and also about the underground water that has been an issue since Avalon Bay blasted and built the complex. And she also said another example of blasting and building causing a water problem in the neighborhood is a property recently built on 1635 Cut Spring Road. And also briefly about traffic traveling downhill on Pumpkin Ground.
Thank you. Thank you. I forget
Can I
your.
respond to a couple of those comments?
Yeah, go ahead.
All right, so as of blasting, it appeared that blasting seemed to be of interest with folks here. I just checked with my client. His knowledge of the topography of the land is such that he's not of the opinion that there's much, if any, ledge located on the site where the additional house. Keep in mind, we're only going to be building one additional house here. But if that is in fact the case, it wouldn't require blasting. It would be of a sufficient type of ledge problem that could be addressed through drilling. And of course, you know, that's not a zoning issue. It's a building department issue. It's an issue for the contractor and his license and his insurance to ensure that there's no adverse effect in terms of any development of the land as it relates to the neighbors. So, you know, for what it's worth, I want the neighbors to at least know that that's something that will be dealt with by professionals. And, you know, we're not talking about a large-scale development here. We're talking about one additional single-family house. So I think that their fears really should be allayed by that. So.
Thank you. Yes, our job as planning is more about splitting the land.
Right.
The discussion of the blasting and the building is more building permit and zoning. So
Yes.
just keep that in mind. He had to present a site plan for a building, but we're just discussing splitting the lots, okay? Joe, do you have another question?
Yes, the health department report suggests that the developer should consult a geologist and a hydrologist. Has that happened, or is the
It has.
developer just speaking about his own opinion of that there's
No,
little or
it-
no ledge?
It has not happened, but if this commission wishes to make that a condition of approval, we would certainly abide by that.
Thank you. Yeah. Okay, thank you very much. We're going to open it up to
All right,
comments from the public.
thanks.
Okay, so I now will be asking members of the public to comment in favor or opposition of the petition. I will also allow general comments and observations from those who are neither in favor or opposition of the petition. Each member of the public will be provided 3 minutes to make their arguments. If someone wishes to speak again, you'll be given a chance after everyone who signed up to get their chance to speak. Okay. Is there anyone who wishes to speak in favor of this subject petition? Raise your hand now. Okay. Seeing none. Is there anyone who wishes to speak in opposition of the subject petition? Please raise your hand. Okay. 3. So when you come up, right after you speak, if you could sign the piece of paper with your name as well, just to help us with spelling and your name. So if you could come up one at a time and speak speak. Please introduce yourself by name and address.
Hi, my name is David Crosby. I'm at 125 Pumpkin Ground Road, which is adjacent to the property we're discussing. My wife and I wrote that letter. So I'm really here about, do you have any questions about the letter? Do you understand what we were talking about with all the water problems in the area and the hill and this, and obviously I'm not crazy about having my backyard and my front yard. I'm just not crazy about it. But again, any questions of me about the letter?
I went out to the property and I know it is sloping, it's hilly. Does water pool on any of those properties along Pumpkin Ground when there's heavy rain?
I'm sorry, I didn't.
Are there low spots where water pools when it rains?
On the 75? I don't know.
Along Pumpkin Ground, along
Street?
on the lawns as the lawns approach Pumpkin Ground Road?
I don't know.
Thank you. I don't have any other questions or see any more. I appreciate it. Next. Again, please introduce yourself and say your address.
My name is Guy Soros, and I reside at 45 Twin Oaks Terrace. A couple of things. You just hit on the sloping of the property and the drainage. I know you've been out to the property. There is a drainage problem based upon the plot plan and the sheer layout of the property that we're talking about. And I have some photographs of the property that demonstrate the slope of that property. Mr. Crosby's property, which is right next door to the subdivision plan, the way the property slopes from the existing house on the property down to Pumpkin Ground is pretty severe. There is nothing on the plot plan that describes the slope of that property. The regulations for the town require that there be a slope laid out to see whether it is moderate or severe. There's nothing in this plan. You got some elevations and stuff, but it leaves this board to figure out what that means as far as a slope. You have no idea about the distances from the existing property down that hill, and a portion of it already is slanted toward Mr. Crosby's property. So there's a slope going straight down to Pumpkin Ground as well as off to his side. And I do have, I'll send up a photo. I don't know how you want to proceed with that. That is a picture from the corner of the property. The house at the top of the photograph is the existing house as it sits on the property now. So it is a pretty severe slope. Also, I have a well on my property. There is no water, city water, that runs in front of my home whatsoever. So far, I've been very fortunate not to have a problem with my well. But this property will require, the subject property will require some blasting. You know, I've lived in that area since 1991. There's nothing but ledge up that way. Nothing but ledge. So I would think that if you're going to grant a subdivision, that there be a substantial bond posted to cover those costs in case there is damage to my well as well as my other neighbors. Mr. Crosby has a stone foundation, which is cemented. He's got a very old home, and chances of that type of blasting can cause substantial damage to his foundation. So having said that, and I do have another photograph taken from Mr. Crosby's side that shows the slope coming into his driveway. So there would be a drainage problem both onto Pumpkin Ground where it is now, because he's gonna, what has to happen is that half of that hill has to be taken away to put a home in. So for those reasons, I severely object to the subdivision, especially since there's no slope plan. I read the map, I have a copy of it. There's just nothing there to substantiate a division. Thank you for your time.
Thank you. Was there one more? Again, if you could introduce yourself and your address, please.
Good evening. My name is Robert Faust. I live on 102 Pumpkin Ground Road. I am opposed to these two houses being built, primarily because I know they're going to have to be blasting, and my house just couldn't stand that. It's I don't know where he came across with this idea of putting two houses there, but he's got to be out of his mind. That's all I got to say.
Thank you, sir. Okay. Was there anybody else? Okay. Is there anyone who is neither in favor nor opposition but wants to provide comments on the subject? Okay, go ahead. And if you could please state your name and address, and if the three who spoke, please put your name on the sheet of paper as well.
My name is Mike Palmieri. I live at 35 Oak Ridge, which is directly across from the lot in question. And my house and the house that sits on the property that we're talking about were both built in the 50s out of blasted rock. My house and that house there by Art Drittenbass. So I know that there's ledge there. And as a matter of fact, if you were to go a couple hundred feet down the road on Pumpkin Ground before you get under the Merritt Parkway, there's a 20-inch water main there that's only 18 inches deep because they couldn't get it any deeper there. When they were building Avalon, fire department had problem because they couldn't get the fire trucks underneath, and they tried to lower it. They did a little bit, I guess enough to satisfy the fire department, but there's really no place else to go. And if you look to the right, if you were going underneath the mirror there, there's ledge 15 feet coming out of the ground, right up to the, pretty much the level of the Merritt Parkway there. So the issue that we're talking about of probably not having ledge there is, I think, is a complete falsehood. I don't have the same problems that a couple of the other neighbors there have. I'm sitting up higher, and I don't have a basement underground. But I do feel for them, and I'm not in favor of the project. Thank you.
Thank you for your time. Okay. Would the petitioner or his representative like to speak as a rebuttal? Thank you.
Yes, thanks. Just a couple of matters of rebuttal. So, I do a lot of work in Milford, and subdivisions in Milford are done a little differently. The subdivision regulations in Milford require you to come in with a drainage plan, a landscaping plan, a lighting plan, all of those things with your subdivision application. It appears here in Stratford it's done a little different. Well, in terms of the drainage specifically, it's my understanding that the drainage, there will be an engineered drainage plan for this. The neighbors seem to think they're looking at pictures of the land as it exists now in the existing condition. But if this application is approved prior to Mr. Sorockman getting a building permit, he has to come in with an engineered drainage plan. So what I'm saying is, you know, there is going to be a drainage plan that's going to be designed by a civil engineer that is going to collect on-site water and infiltrate it and make sure that that's dealt with. So I think that there's a disconnect in terms of, you know, the knowledge of that, and I just want to assure not only this commission but also the neighbors that an engineered drainage plan will be supplied. And then secondly, in terms of the blasting, keep in mind my client does have options here. So if he starts to do borings and it turns out that there's all ledge right there, and it's an extensive amount of ledge, and it would require blasting, he can then change his mind and have the houses on slab. So, you know, again, I want neighbors to know that that's going to be addressed. And the gentleman who spoke of a bond, I don't think that's appropriate. I think he would be protected by the contractor who would be doing the work and his liability insurance to make sure that you know, the netting and the padding and everything else that's necessary to ensure that no vibrations leave the site and affect wells or foundations of nearby property owners, that would be taken care of at that time. But again, I'm making the point that there is an option here that if it's an extensive amount of slab, and that's what everybody's worried about, the houses can be built, I mean, extensive amount of ledge, the houses can be built on slabs. So again, a lot of these are not really zoning issues. I think the commission, I'm asking you respectfully to focus on the zoning aspect of this and see that it does meet your residential zone standards, it meets your plan of conservation and development, meets the standards of Connecticut Statute 825 and your subdivision regulations. And I'd ask that you approve this application. Thank you.
Thank you.
Madam Chair, can I respond to some of the comments as staff? So there are a couple of things I want to bring to your attention. One is about the slopes. The slopes have been identified on the survey that was provided to us. our regulations require 2-foot contours, at intervals of 2 feet contours on the map, and they have been shown. So the highest point on the site is at 154 feet, actually 156.48, and then the lowest point is 138 feet. So it's roughly 20 feet difference. It slopes down from Oak Ridge Road side to Pumpkin Ground Road side, but the way the buildings have been oriented is not in the direction of the slope, but against the direction of the slope, facing Oak Ridge Road side. One thing I want to clarify, our subdivision regulations do require drainage calculations, building footprints, lighting, landscaping, and all those. Like, I just opened the regulations on my phone. I think it's page 24 of subdivision regulations. In this case, he showed everything, but there was this question whether he would develop the lots or he's just proposing to subdivide and sell it to a future developer who would come in and build the second home on the other lot. So at that time, Stephanie was not in the office, and I was working on this application. I spoke with John Casey, the town engineer, and he said, based on his 30-year experience working on these with the town, that sometimes we put it as a condition of approval that whoever is going to, develop this lot as a builder comply with the drainage requirements of the town. And also, we often, for every subdivision, we ask the applicant to post a bond as a condition of approval. That takes into account everything that should be considered by the applicant, like erosion and sediment control, sidewalks, drainage, other infrastructure that we think should be put in place accurately, and if it's not, the town can call the bond and implement it on its own. So that should definitely be a condition of approval. Then I looked at John Casey's comments here, and he said, for the above reference application, a single site plan was submitted. There are no drainage calculations or drainage facilities shown on the plan. My comment would be that drainage calculations be submitted and facilities designed to show a no net increase in runoff in the peak rate of flow from the site and storage of 1.3 inches of rainfall permanently on site in order to, make sure that the drainage infrastructure is efficient. Also, there are no erosion and sediment controls shown to prevent sediment from reaching the town drainage system, so he has to comply with the town's erosion and sediment control requirements that are outlined in the town's zoning regulations. And his comments were consideration should be made for the sidewalk on Pumpkin Ground Road to be extended to Oak Ridge Road with a compliant ADA curb ramp at the intersection. Additional street trees should be provided in front of parcel A in accordance with tree warden requirements. A street line monument should be set at the intersection of Pumpkin Ground Road and Oak Ridge Road. House numbering will change for both the new house and the existing house, so it should be clarified where the front door would be located. This can be coordinated at the time of building permit, and sewer connection charges will be required for the additional lot at the time of building permit. So if you choose to approve this, all these conditions have to go as a condition of approval for this application, along with the conditions that the health department suggested, which is that, the developer should retain a geologist or hydrogeologist and licensed environmental professional to evaluate the underlying bedrock's potential. And prior to any active earthwork or blasting, this professional should identify all drinking water wells within a 500-foot radius and evaluate which drinking water wells need to be sampled in order to establish baseline drinking water quality conditions. And all blasting plans require review by the town fire marshal. In addition, any future developer will be subject to the hours outlined in the noise ordinance of the town of Stratford. These conditions should be carried over, along with another condition that our zoning enforcement officer suggested, which is that should the commission choose to approve this petition, the commission may require a pre- and post-blast survey as a condition of approval. And there's one more, I believe I missed. I think that's it, right? So, and a subdivision bond must be posted as determined by the town engineer. That was the last condition I think should be included.
Thank you. Okay. May I have a motion to close the public? More discussion? Go ahead.
Susmitha Kelly Kerrigan says the applicant should consider compliance with our MS4 permit. I don't know what that is.
So at the time of building, they have to take into consideration the Connecticut Municipal Stormwater Permit requirements. Essentially, what John has outlined in his drainage conditions is almost the same as what the MS4 requirements do require, but that all comes at the building permit stage anyway.
With regard to the health department report, I have a question about the timing. I mean, were we as a commission to approve this with the conditions that you suggest, and then we get the health department, the hydrologist report and the well survey, and it shows problems, we've already approved it subject to the report. So my question is, can we table this until we've had a chance to review the hydrologist's report and the well survey?
So, again, this is where, this is not a standard special permit application of zoning commission where you do simultaneous review of the plans and then provide comments on, impacts that would be directly related to building. This is a subdivision application pursuant to Connecticut General Statutes 8-25. He's entitled to subdivide his lot as long as it meets the requirements of the regulations. Now, he could sell one of those lots to a future developer 3 years later. The subdivision approvals hold good for 5 years, and then they can get another extension for another 5 years. So up to 10 years, the approval is valid. So if he chooses to sell the lot to somebody else, and that person is proposing the building permit, he should be doing the, whatever pre-construction work that goes on with respect to blasting, drainage, and other things. Now, as far as building itself goes, we have an internal permitting system, and where the building department, fire department, planning and zoning, engineering, everybody are involved, and it goes through right from the tax assessor. If you default on your taxes, you don't get the building permit signed. So if there is any impacts, unless those are mitigated, you don't get a sign off on the building permit. So it'll just stay in the permitting system as long as they address the, impacts and then move forward. Otherwise, it'll be, at some point, maybe the applicant would realize that this is not a buildable lot, and maybe sometime again, he'll come back asking for a consolidation of lot.
So if I understand, as a planning commission, our concern is not with the content of the reports. Should the reports come back unfavorably, zoning will have to handle that when there's a building plan.
You're going to provide these as conditions of approval, and they will be required to be put on the Mylar that is going to get filed on the land records of the town clerks. So whichever builder comes to develop this lot has to follow those conditions of approval, otherwise they don't get the final sign-off from our office.
Thank you.
Okay.
I see a hand being raised, but you cannot allow them to speak because the public hearing was,
That's what I was trying to do. I need a motion to close the public portion of the hearing, and then we will continue our discussion.
I'm sorry, you're not closed yet. You're making a motion to close.
I tried to, wait a minute. You were not at the podium to speak. I tried getting a motion to close the public portion, and you spoke, and I let you speak. I am closing the public portion of this motion, of this hearing, so that we can continue our discussion internally.
And just for the record, my name is Guy Soares, so I just wanted that out.
Thank you. And those who spoke, if you, like I asked, if you could please write your name down on the piece of paper. I think there's a pen up there. Thank you. Second?
I second.
All in favor? Aye. Do I hear that from Joe and Steve? Okay.
I'm opposed to closing the public hearing.
Okay, so four, want to put, okay. So now we can continue our discussion. Was
You
there some-
cannot, you still have another item on your public hearing. Once that is closed, then you open it to administrative session.
Thank you for
And then you
clarifying.
discuss.
Appreciate that. Okay, so we are now moving on to going back to the beginning of my script, hold on a second. This is the 460 Stony Brook Road. So if the town planner can read read about this one.
The petition is for 460 Stony Brook Road. The petition of 460 Stony Brook Road LLC to subdivide 460 Stony Brook Road into 3 lots with lot sizes of 8,303 square feet, 9,353 square feet, and 12,197 square feet for a total of 0.67 acres, respectively in an RM1 zone. And you would like me to summarize now?
If you want to continue. Okay. Is the representative present? Okay. If you can announce your name and address, and for the record, this was also in the Connecticut Post on both November 4th, 2025 and November 14th, 2025. And you also posted a sign. If you could submit any certificate of mailings if you have them, if you haven't already, and if you could, again, announce your name and address and present your case.
Thank you, Madam Chair. My name is Attorney Benjamin Proto. I have an office. My name is Attorney Benjamin Proto. I have an office at 2885 Main Street here in Stratford. I represent the applicant for this 3-lot subdivision at 460 Stony Brook Road. Certificates of mailing had been submitted previously to the zoning office, and my understanding is that they have received those and have them in the file. 460 Stony Brook Road is currently a single lot comprised of approximately 30,000 square feet, or about 2/3 of an acre, about 0.67 acres of land. It has one 2-family house that's on it right now. The applicant is proposing to subdivide that property into 3 conforming lots, all of which would exceed the minimum lot requirement with an appropriate building box with the appropriate setbacks. There are some additional structures that are currently on the property, some sheds along those lines. All of those would be removed. The only thing that would remain is the current residential structure there that would become one of the units on the 3 lots. The lots are fully compliant with our RS3 zone requirements and RM1 zone requirements that it currently is located in. And as such, the lots meet all of the requirements for a building lot in an RM1 zone. We would ask for the approval. There have been some issues with the maps that have been presented. You have those in your comments. While those issues are easily rectifiable, Madam Chair, as you said in the last hearing, it's your job to look at the creation of the lots and do those lots comply with the requirements. Any of the requirements that the staff comments indicate are not there. We disagree that some of them are there, are easily rectifiable as an administrative review upon a condition of approval. So we can go through those. There are 10 items that were listed. One was the zoning compliance table. There says there's no existing conditions for the 3 lots. Well, there's a reason for that. The lots don't exist. If the lots don't exist, there's nothing to put those to. Secondly, there's no legend to differentiate. All maps had the legends. We more clearly defined the weighted, excuse me, the weights in the drawings. That's, again, easily rectifiable, has nothing to do, all of these things that staff comments rectify have nothing to do with the size of the lots, the location of the lots, whether the lots are compliant or not. They're all items that appear on a map that, again, are easily rectifiable. Building coverage, the current lot, which would be Lot B, where the house is, we showed it originally at 11.8. The zoning office said they thought it was about 15%. It's actually 13%, whether it's 11.8, 15%, 13%. Maximum building coverage is 33.3%, well under the maximum allowed. So again, easily rectifiable. We have issues regarding square foot discrepancies. Again, that was a differentiate when we prepared the application. Quite frankly, that was a mistake on my part in the application. Again, easily rectifiable. What shows on the map is correct and remains correct. Regarding property descriptions, it's unclear as to what property descriptions they're referring to, as the lots don't exist, but the property description for the current lot is correct, the overall .67 lot. Regarding underground utilities, there are currently no underground utilities, so there's none to show. As to potential future underground utilities, those are easily put onto the maps and have already been put there. Existing and proposed trees. The trees that are shown on the map are existing. There's no proposed additional trees to be put in. Again, easily just marked as existing as opposed to proposed. And the location of the sidewalk, the original map didn't show a sidewalk. The new map can easily show a sidewalk, and we're prepared to put the sidewalk in. So of the 10 items, 10 are easily correctable and have nothing to do with the creation of the lots, the size of the lots, the location of the lots, or whether the lots comply. The town engineer has provided some additional comments as well, one of which I think is more appropriate upon the filing of an application for a building permit, as Susmitha indicated on the previous application. The WPCA issue clearly is one that goes to once we decide, or the developer decides what they're going to do, as to connection fees and whether it is. And regarding the drainage situation, I believe what Susmitha had read, and correct me if I'm wrong, Susmitha, because I was looking at it as well, and you said page 24, I didn't quite see it. I did see, however, if the elevations or the contours exceed a certain minimum, that drainages have to be shown. In this particular case, it's a flat piece of property. There's no changes in elevation. And the drainages will not exceed what is currently there and will be fully compliant, and a drainage plan would be submitted. We would fall under the MS4 requirements, as was indicated earlier by Mr. Jarrett, because we have to, and we will comply with all of those. So while the issues raised by staff are, I think, more administrative than they are in regards to the creation of the lots and whether the lots are in compliance, because even if all of these were on the original plan, the plan would still look exactly the same. The lots would still look exactly the same. They'd still be designed exactly the same. There would be some additional information related to the lots, none of which change whether or not the lot is compliant. So with that, we would ask that the commission approve the application for the 3-lot subdivision with the conditions that the maps be updated, which they already have been. We could easily hand those in tomorrow morning with all of those changes on there and meet all of those requirements. So, Madam Chair, with that, I'm happy to answer questions, but again, we think the subdivision makes sense. It meets the plan of conservation development of providing additional housing. Also, what's interesting about it, and some of you will not have to deal with this as you leave the commission. If you're moving over to other commissions, you will. The new housing bill that was recently passed, this particular development, because of the way the bill is written, you would get 1/4 point for each unit. So there would be 6 units. That would be 1.5 credits for this particular development to meet your moving to your 10% requirement under the new bill. So this would actually help the town move forward in regards to its requirements under the new law that was just recently passed and signed by the governor. So with that, Madam Chair, I'm happy to answer questions from the commission.
Thank you. I do have a question. So as you said that you had answers to all 10 things, why not correct them before tonight instead of correcting them in front of us? Because we, in my opinion, we can't provide conditions of approval if you're just going to correct them tomorrow morning.
Well, there's a reason for that. Your hearing is tonight at 6:30. We received all of those yesterday afternoon at 4 o'clock. And with all due respect to staff, giving us staff comments 25 hours before a meeting doesn't really give us a lot of time, and as it was, we were able to get our engineer to fix as much as he could in that time. It's also my understanding that staff comments were done over a week ago. It was, I told tonight. They weren't sent to us. I was told they were posted on the website, but if you don't know that they're posted on the website, I don't go running to look at the website every day, as I'm sure none of you do as well. So again, with all due respect to staff, my feeling is, and although staff comments are not required by law, the moment they are created, they should be given to everyone. You, me, the applicant, everyone who's involved in this, not the day before.
Does anyone else have any questions for Mr. Proto?
I do. I'm just a little confused about the number of units here. You mentioned there's 6 units?
I'm sorry, 9. They're 3 family. I apologize, 9 units. My apologies. I was thinking of another one that you're gonna talk about later on. There are 3 family lots.
It's 3 family, not one. I thought it was 1 2 family.
Well, the original is 2. The current one is 2, and the other 2, I believe, are 3s.
Okay.
So that would be 6, 8. So that's how, yes, that's how we get to 1.5.
Thank you.
I had the math right, I had the number wrong.
Anybody else have a question for Mr. Proto? Okay.
Madam Chair, we'll hold off our comments until the rebuttal is done.
Okay.
Thank you.
So if you could summarize the staff report, or you'll do that later?
I think you can ask the public to testify
Okay.
first.
Thank you. We're going to ask the public to speak now, if you wanted to have a seat. Okay. So I'm going to be asking the members of the public to comment in favor or opposition, just like last time. I will allow general comments and observations from those who are neither in favor or opposition. Each member of the public provided 3 minutes to make their arguments. If someone wishes to speak again, you'll give it a chance after everyone who signs up gets their chance. So, is there anyone who wishes to speak in favor of the subject petition? Okay, seeing none. Is there anyone who wishes to speak in opposition of the subject petition? Please raise your hand. Okay, seeing none. Anyone who wishes to speak in neither in favor nor opposition, but provide comments on the petition? Okay. So,
Give an opportunity for rebuttal,
rebuttal to what, though?
if he wants to rebut anything.
Do you, okay, do you have a rebuttal to anything? I think yeah. Do you have a rebuttal to anything that we've, I think, because we asked our questions and he was able to speak already. So,
I don't think there was anything
yeah, I didn't think so either.
to rebut unless I, of course, once staff completes, I would ask the opportunity.
So if the staff could please summarize your report and give your rebuttal to his
So,
presentation.
Madam Chair, I would have Stephanie summarize, but before Stephanie joined the office, there is history to this application that I want to bring to your attention. So on August 28th, 2025, the applicant came to our office seeking our professional opinion on this property and on 0 Broadbridge Avenue, which you will actually review as part of administrative items. And I told in my email to the applicant that this property is located in an RM1 zone. The zone table shown on the map is inconsistent with the dimensions shown on the drawing. It does not include dimensions for Lot 1B proposed, and Lot 1A is also titled incorrectly in the zone table. This proposal meets the dimensional standards of the zone provided these changes are made. All applications for approval of subdivisions should be made with the Planning Commission, which has the final decision-making authority. After that, the applicant came with their application and they submitted, and the first drawing, I also informally spoke to the applicant, and when that applicant was in my office, and I said, we need you to give us the right set of drawings. As long as you give the right set of drawings, this is a very simple subdivision. There should be no issue with it because it is consistent with the plan of conservation and development. We got the same map submitted as part of the application when it was submitted, and I think it was submitted in September or something. And then Stephanie emailed on October 23rd to let them know the items that were missing. On October 30th, we received revisions. On October 31st, we responded back again saying that there are still issues and asked them to review the subdivision regulations and correct their drawings. And then we have our subdivision regulations posted online. And if I can just read one section in the subdivision regulations on site plan, it says the site plan accompanying the proposed subdivision shall document additional site information to assist the planning commission and the town departments in understanding how the proposed subdivision will function in the context of its surrounding geography and public infrastructure. The site plan should include all additional information not required for the record subdivision plat, including the following, and there is a bunch of requirements on this on pages 25 and 26. So my point is, we also heard the attorney for the other applicant just a few minutes before, and he was surprised, how is Stratford even doing this? In Milford, you don't even get the drawings, approved without having all these requirements. So you have a bunch of regulation requirements, and you are supposed to check off these requirements. All that you have to do, every applicant is required to do it. So why resist? Why can't you just follow the book? Finish what you have to do, give us what you have to do. We approved so many subdivisions as part of this planning commission in the past couple of years. There was never a time when I received any resistance from any applicant saying, I will do my drawings later, I don't know why these are required. You have to follow the book. If you follow, whether it applies to your subdivision right now or not, change the regulations if you think the regulations are not applicable. But as long as there are regulations, we have to follow the book, and that's what we're trying to do. And considering, about the staff report, statutorily, we are not required to give our staff reports to each and every applicant, call them and tell them to read my staff report. Our staff report is a technical staff report for the commission, to guide the commission. We do post it online so the applicant reviews it and comes prepared. We want to give him an opportunity to review and fix the drawings, but you should also understand, if the applicant doesn't have time to follow up 1 week before and ask, hey, do you have any comments? We are dealing with 10 different types of applicants, not just for planning commission, for zoning commission, zoning board of appeals. So we have, thrice the amount of workload that we're dealing with here. We can't call every single applicant and say, did you see my staff report? I posted it on the website. No, you have to follow up with us. And like any municipal government, if you go to, I was just telling the attorney, if you go to a driver's license facility, you don't have the right paperwork, you don't get your license. You gave me the right drawings that comply with the regulations, we will say everything's fine. And we haven't had an issue with any applicant in the past on this. You can summarize your staff report.
So the applicant is proposing to divide the subject property into 3 residential lots to build a 3-family home on 2 of the new lots, leaving the existing 2-family home on the 3rd lot. Subject property is located in a residential 2 and 3-family RM1 zone. There is 1 2-family home, like I just said, on this lot, currently with frontage on Stony Brook Road. The total area of the parcel is 0.67 acres approximately, and the minimum required lot area for a lot in an RM1 zone is 7,500 square feet. With the proposed split, the 3 zoning lots would be created of the dimensions I mentioned earlier. The site has an elevation difference of roughly 4 feet from east to west. Through my review of the application and supporting documents, I found that there were a number of requirements, as we discussed already, that are missing from or incorrectly listed on the revised subdivision map that was provided. I will list them. So there is no existing conditions column in the zoning compliance table for the existing lot. There is no legend to differentiate the line weights in the drawings. The listed building coverage for proposed lot B is incorrect. It is listed as 11.8%, which is the same number that was listed for lot C, which has no proposed building, but it should be around 15%. The application and preliminary subdivision map do not list the same square footage per lot. The property's legal description does not match the meets drawn on the preliminary subdivision map or the property survey. There are no monuments included, which is something that is in our subdivision regulations. It was unclear whether underground utilities are all included and whether they are existing or proposed. Requirements for underground utilities are not noted on the preliminary subdivision map. Both of these our regulations and our subdivision regulations. It is not clear whether the trees listed are existing or proposed, and there were no location for proposed sidewalks. Currently, the subject property has no sidewalks, but the abutting properties on either side off of Stony Brook Road do. There are a number of town staff comments provided. I'll start with the town engineer. On an email dated November 12th, the town engineer said, "I see only a subdivision record map. The lot configurations are oddly laid out, which could result in future owner-related issues. The street line should be adjusted at the angle point of the road to provide a standard road radius curve. Driveway site distance due to the curve in the road will need to be sufficiently provided. The lot lines create encroachments of existing sheds, garage, driveway. These should be remedied. There is no site development plan, sediment and erosion control plan, drainage calculations, drainage mitigation, etc., upon which to comment. So my comment is that these to be submitted. In general, for stormwater concerns, we would want the development to be in compliance with MS4 directly connected impervious area goals and no net increase of peak runoff from the site. Also, we would want to make sure that no drainage impacts would result to the adjacent neighboring properties. For the wastewater, the Stratford WPCA approval would be needed for this type of development. This property also flows into the city of Bridgeport sewer system, so Bridgeport WPCA approval may also be required. The town health department also provided comments, the gist of which were that given the year the existing single-family home was constructed, an EPA certified firm will be required to conduct any activities related to renovations for anything that would disturb paint due to the likelihood of lead exposure. So the consistency with the plan of conservation and development, the future land use map in the PUCD recommends both high and medium density residential land use for this parcel. I'm sorry, yeah. So the high-density residential areas incorporate predominantly multifamily homes that promote diverse housing options. Generally, these have 5 to 11 dwelling units per acre. Medium-density residential areas incorporate predominantly single-family homes, in addition to some multifamily structures that promote diverse housing options. So generally, these areas have 2 to 4 dwelling units per acre. The proposal is to subdivide the subject lot to accommodate 2 additional 3-family homes and maintain the existing 2-family home. Yeah, I think I just, it was a typo. Thus, it is consistent with the future land use map recommendations of the POCD. And the proposal also meets the following housing objective of the POCD, which is objective 3, enable more housing choices and options than what exists currently. So in conclusion, while the proposal is consistent with the future land use and housing objectives of the POCD, there are a number of inconsistencies and required items missing from the application, as I noted. More information is needed on various elements of the proposed subdivision before a final decision is made. The commission should consider continuing this application to allow the applicant to submit the required components.
I also want to add regarding the comment on there's nothing existing. There is one lot existing. When the zone table is shown on the map, you have to show the one lot as existing with the single-family home and the standards that are there. And then you show on the zone table the zone standard requirements for that particular lot. And then you show the proposed 3 lots, how that one lot is going to be changed to those 3 lots. The meets and bounds and the legal description are very important because when these lots are sold in the future, some new owner buys it and says, this is part of my lot, and if you don't have accurate descriptions, it can get into a gray area there. The other thing is also, in general, about street trees. We were not able to determine which ones are existing or proposed. And if we don't know if you're proposing new trees, they have to be reviewed by tree warden. And she has to approve the type of trees that will go on the street side. So we were not sure which ones were existing and which ones were proposed. This is why the requirements are in place. It's not to create an added layer of bureaucracy here, but just to make sure that whoever buys these lots in the future has the same kind of information, and whatever we are approving here is consistent with the goals of the POCD and trying to make sure that it has no adverse impacts.
Thank you. Do you have a rebuttal, Mr. Proto?
No rebuttal in particular. However, I do have to get on the record, because I do think this is important going forward for, particularly as we have all new commissions coming in place. And I have great respect for the staff. I've worked with Susmitha for a long time, and I look forward to working with Stephanie. When I hear we can't call you all up, but you have the ability to email me the day before when you've had the comments for over a week, that's a problem. And I think this commission and the zoning commission and the ZBA need to address that with their staff. That once you create, if you can email it to me on Monday night, you could have emailed it to me a week ago. That's just, it's so obvious that it shouldn't even have to be stated. We could have dealt with this a week ago if we had known about it a week ago. You didn't have to call me up. You email me on a regular basis. So that's an issue that I think all three of these commissions need to deal with, to ensure that once if you're going to create the staff comments, and they need to go to everybody. As for the other issues, some of which I think are way form over substance and are easily correctable, some of which I think are more interesting to me, that if it doesn't say proposed trees, therefore we're assuming they're proposed trees, things along those lines. So at the end of the day, we can correct all of these things, and the lots are still going to look exactly the same. They're still going to be the exact same dimensions, with the exact same sizes, and the exact same conditions. So we can do it tonight with a condition of approval, or we can come back next month and you can approve the exact same thing you have in front of you right now. It's, of course, I don't know if you're meeting next month during December, because those tend to go off. So if not, then we're coming to a new commission in January. So again, we would ask for an approval with the conditions. Thank you.
Thank you.
Madam Chair?
Yes.
Can I don't want to argue. I don't want,
Yeah, it's gonna- I don't-
no.
I don't wanna
Madam
go
Chair,
very
this is
long.
not back and forth. I just want to tell you, we had sent 3 emails. 3 emails saying you have to fix your drawings. We cannot babysit them. I mean, I
You had the
understand,
la-
I
and-
understand.
And you had the last
This
map
is
from
not
us
his
2
opportunity
weeks
to
ago,
speak.
Okay, both of
Susmitha.
you.
This is not his.
2 weeks.
We've heard you. Thank you.
And then the other thing I wanted to tell you is Stephanie sent to you all comments on Thursday, I guess, or Friday. She was waiting on information. She was waiting on information from other staff. But the drawings themselves, the corrections to the drawings, were told in 3 emails, multiple times. And I'm not saying this has to be approved. This is a very good subdivision. I mean, it is consistent with POCD. But my problem with providing this as a condition of approval is now we have to chase the applicant as staff.
Right.
Once it is approved, we will be chasing them to fix their drawings. And that is my only concern with this. And regarding the December,
Thank you, Ed. May I have a second to that?
Second.
Aye.
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 Hello? There we go. Okay. So now we are moving on to the rest of the agenda, which is, okay, so this isn't listed. Do I now open it up to discussion back to and get approval rather than a subdivision? Yes. So we're going to open up, can I get a motion to open up for internal discussion for 75 Pumpkin Ground Road?
So moved.
Second?
Second.
All in favor?
Aye.
Thank you. Okay, so do we have any internal discussion further about 75 Pumpkin Ground Road?
I do, and I wanted to run this by the other commissioners. I think it would be good for us to get a list, because there's a lot of things here, right? There's a lot of conditions if we're gonna do any type of, and I would just like to get a list of what are all those conditions, because we've got the engineers, the town engineers' comments on this, we've got, the health department, drainage requirements. You know, I'd be okay with approving this, but I think we have to have some very serious conditions about this approval, right? That those need to be on there. And that's kind of where I'm leaning at this point, and I think it would be good for us to come up with those conditions.
Rather than, I agree with you about conditions, can we, rather than listing and itemizing them, can we say a summary of the conditions given by engineer, conditions given by Shafter Health Department, by zoning, and you listed one more? What was the fourth one you listed?
There was a drainage requirement
That was within engineering.
that was separate from what was in the staff report, I believe. I just want to make sure we capture everything.
And I would also like to add, Susmita mentioned about normally there's bonds requested for this type of thing. I think that should be included as well, because I think there needs to be something to protect the people who do live in the area.
And if we did a bond, would we have to give a number?
So that'll be determined by the town engineer. He will calculate it and provide that estimate. Also, when we write our condition of approval, we watch the video again. We look at the notes, everything, and then we list everything from the staff comments by watching the video and by looking at the staff comments, so nothing gets missed.
Great.
So I'm sorry to interrupt, back to the original question, are we able to just, because I agree with Ed completely that, you know, I don't have a problem approving or recommending approval, but to make sure all of these issues plus the bond are addressed so that any of the residents' concerns are addressed.
You can make a motion saying that if you were to approve this with conditions, consider all the conditions that were discussed in the public hearing record, and as provided by the Public Health Department, the town engineer, who else? Conservation Department, and also make sure that a subdivision bond is required to be posted as determined by the town engineer.
The fourth one is zoning, so conservation and zoning. Great comments. Does anyone else have any comments? Okay. Who would like to present the motion?
Well, I'd like to make a motion to approve the 75 Pumpkin Ground Road petition on the following conditions: that we meet the requirements of the town engineer, that the town engineer places a bond on so that those requirements are met, that they meet the Stratford Health Department's requirements, the Conservation Department's, and also the zoning requirements.
Thank you. And a second?
Second.
All in favor?
Aye.
Thank you. Passed unanimously. Okay, now moving on to 460 Stony Brook Road. Can I get a motion to open for discussion?
So moved.
Second?
Second.
All in favor? Thank you. Does anyone have any comments or discussion about this application?
I guess I'll jump in here first. I am definitely leaning that, especially if all of these concerns are so easily corrected, for whatever reason, we should be voting on accurate information. So my recommendation would be that we continue this application until the December meeting and until everything's been updated.
Do you have any more comments?
I agree with Steve.
Any other comments?
Yes, you have an administrative item to review that is referred by the zoning commission, so you will have a December meeting. If not, we should call in a special meeting at least, if you can make it to the regular meeting date, and just get this business taken care of before new commission comes over.
You can ask it. I'm not sure if we're going to be able to answer it. We didn't table the hearing, that the hearing, the public portion was closed. But, but we'd still be able to make a more informed decision with more information. Okay. Yep. Okay.
So, Madam Chair, if you cannot present any more information, I would ask this commission to consider, do you want to vote an approval on incomplete information?
Comments on that?
Someone should look at that, huh? Yeah, if only you knew an IT guy, right?
I'm not trying to be adamant here. I would like to work with the applicant. If you want to propose as conditions of approval, that's fine. But I'm only telling you that the Mylar has to be filed on the land records. And as long as the applicant really promises to actually get us the accurate drawing this time around, where we have to not call them 5 times, I think it should be okay if you provide us conditions of approval.
So I guess I'm just asking a question here, you know, and then this is your opinion. Of the things that we're asking to be fixed here, are any of these game changers, right? Are any of these like, oh, no, you better not say yes to that without knowing this? Now, I understand where we're coming from. I understand maybe some of this, we'd look at it and say, maybe it's incomplete, maybe it's a bit sloppy. But, you know, is any of it like, no, we can't approve it? And you know, then if the answer to that question is no, then, you know, I would be more, hey, let's get a list of the things that need to be fixed and approve it in this meeting and move it forward.
Madam Chair, I move that we continue this to the next meeting.
Let Mr. Smith answer his question first, please.
So I think, I feel like the street trees would be a concern. If they're proposed new trees, Kelly Kerrigan has to look at them. And the legal description really matters, meets and bounds. That has to be really fixed. And if you choose to continue for discussion's sake as an administrative item, you can continue. You don't have to make a decision tonight. And if the applicant in good faith is going to show something to the, you know, department, we are willing to, you know, I would be the first person to recommend an approval for this because this is a good subdivision. I told first time the preliminary review came. It's just that we are frustrated with the amount of paper that we are receiving every time, and every time there's a new correction on the drawings. And I mean, no offense to the attorneys or the applicants or anything, you need to have good architects who can do these drawings for you in one go. That's all I'm trying to say here, that's all.
Then let's go that way. I think Joe has something to say.
I move that we continue the matter to the next meeting.
Do I have a second to that? All in favor? Thank you. Now we're going to move on to the subdivision waiver for 75 Pumpkin Ground Road for the sidewalks and underground utilities. So was there any more that the staff had to summarize for this?
Yeah, you cannot provide waivers of subdivision regulations without receiving a report from the town engineer. And in this case, the town engineer has recommended sidewalks and you know, so the sidewalks have to be kept because that was his recommendation, and he needed a supermajority vote for waivers, so you need 4 out of 5, not 3 out of 5. So if you want to vote either way, you need 4 votes, whether to approve or disapprove the waiver.
Can I speak addressing that, or is this, it's not a public hearing, but?
It's an administrative item, yeah. He can.
You can speak, yes.
All right. So am I correct in interpreting what you just said, that in my presentation to the board, we were requesting a waiver of the sidewalks on Oak Ridge? We were going to adhere to Mr. Casey's recommendation to bring the sidewalk on Pumpkin Ground up to the intersection. So are we on the same page?
What he wrote.
Okay.
One second. Is that what he wrote? Okay, whatever John Casey recommends has to be kept, yes.
And I think that makes sense, because if you look, there's no sidewalks.
Right, and I
on
had made that comment in my presentation to you, and I just wanted to get that clarified, so, all right, thank you.
Okay, does anyone have any questions or discussion about this topic before a motion? Can you turn?
At the last meeting, I raised the question about other lots in that neighborhood that are also likely to be subdivided in the future because there are similar circumstances to this one. And there will be increased density over the next few years as that process unfolds, and there will be more pedestrian traffic. So I personally would not like to see a sidewalk waiver for either street. I would like to see sidewalks all along the property.
Thank you for your comment. Does anyone
Madam
else?
Chair, can I just respond to
Sure.
Commissioner Garrick's concern? The only problem is on one side of the street, if you look at the, property itself in street scale, there's sidewalks, I think, on Pumpkin Grove Road side, but on Oak Ridge side, there's no sidewalks nearby at all. So that's a connection to nowhere. Like, it's a wide road, but there's no sidewalks on other properties at all.
Yes, but I'm anticipating future development on that other street, and that's what I'm concerned about.
Does anyone else have any comments or discussion on this topic? Okay, can I get a motion?
I'd like to make a motion to approve the waiver of the sidewalks as long as sidewalks are built on Pumpkin Hill Road as defined by the town engineer.
Pumpkin Ground.
Sorry, Pumpkin Ground Road. No disrespect, sorry.
And a second?
Second.
All in favor?
Aye.
Any opposed? Thank you. It also listed underground utilities, but those weren't talked about. Is that just a mistype?
I didn't receive any comments on that from town engineer, which means that, first of all, there is no building activity proposed. It's just more like a subdivision that you're approving, so you don't even know what kind of utilities are going there and if they have to be undergrounded or not. So I don't know, at this point, should you waive this, or should you have them come back if they want to request that waiver in the future when they're building it?
If just a comment on that, the utilities come in on the other side of the street. There's a pole that the utilities go over the street, and then from that pole it goes to the existing home. I don't know how you would do, what are you gonna do, underground from the pole that's already there across the street? It just doesn't make any sense to me, just my observation.
Any other discussion or comments? Okay, can I get a motion on this?
I'd make a motion to approve the waiver for underground utilities.
Second.
All in favor?
Aye.
Any opposed? Thank you. So that passes. Okay, moving on to the next one. Now we need an approval of minutes from the regular October 21st, 2025 meeting. Can I get a motion for approval of those minutes?
Motion to approve minutes of the October meeting?
Second.
All in favor?
Aye.
Thank you. Okay, so now we have two zoning commission referrals. The first one is 100 and 150 Oronoke Lane. Will you please give your staff comments? Summarize from you. Thank you.
Yes. So the modified petition of M Slade Enterprises LLC seeking a zone change and text amendment to create a new zone for the subject properties titled Oronoke Golf District, section 3.3.7 proposed. The applicant is proposing a change of zone for 100 and 150 Oronoke Lane properties from RS1 to Oronoke Golf District, which would permit the development of 32 townhouses with 32 parking spaces. There will be 10 units designated as affordable and deed restricted for 40 years as a set-aside development, and the existing single-family homes will be removed. The RS1 zoning district currently allows for the development of single-family homes on lots of at least 40,000 square feet area with a maximum impervious coverage of 20%, building height of 30 feet, and building coverage of 10%. The subject parcels are within 300 feet of Roosevelt Forest land to the west and wetland soils to the east. There is a special flood hazard area located to the east of this parcel, which is flood zone A. The subject lots are currently served by a septic system, and one of the lots received an approval from WPCA in recent past to extend public sewer to construct only one single-family home on 150 Oronoque Lane property. The Planning Commission recommended an approval of extension of public sewer connection for one single-family home on this lot in November of 2024. An 11-unit detached single-family condominium development containing 3-bedroom units was recently approved on the neighboring 170 Oronoque Lane parcel to the east as part of a legal settlement between the town and the developer of this parcel, for this parcel. There are no sidewalks in the area and no immediate public transit service in the vicinity for households that rely on such service. Based on Connecticut Environmental Conditions online map, the 150 Oronoque Lane parcel and its vicinity are identified as a natural diversity database area consisting of state and/or federally listed endangered species. The subject properties do not have public sewers and are located in sewer exclusion area designated by the Water Pollution Control Authority, which was officially adopted on May 29th of 2025. A few notes via a zoning analysis. There's no modified existing condition map.
It's needed for this because it's a referral on zone change. That's more for the zoning commission.
Okay. So just go to comments. Sure. Well, there's a number of staff comments that were submitted. The town engineer, in an email dated November 12th, stated the following. Sanitary, the properties are located within the sewer avoidance area as approved by the Stratford WPCA, and therefore it does not seem that the property will be allowed to be served by the public sewer according to the ordinance. Stormwater quantity. Regarding the downstream drainage area, there are known flooding and erosion issues downstream to Freeman Brook. No increase in the runoff should be allowed from the development in order to ensure that there would be no impact downstream. For a review of the previously proposed development, I commented on the soil's potential inability to accommodate on-site infiltration as previous test pit data shows hard pan and ledge on site. Therefore, less impervious area on site is more desirable to limit runoff generation. Site development is required to be performed in accordance with the state stormwater quality manual. This includes designing with low impact development techniques, reduced impervious areas, compliance with MS4 goals, etc. It is not clear from the submitted materials that the proposed development meets this criteria. The health department also submitted comments for this application. The proposed development will need to be connected to adequate drinking water and sewage infrastructure. Potential for impacts to drinking water, well quality, and yield on nearby properties as a result of site development activities should be assessed and mitigated prior to any future development of the subject properties. Where any significant earth removal and/or blasting activities are to occur, there is concern for possible negative effects. The police department also offered comments regarding this application. Their main concern is the location of the driveway and how it may impact traffic safety on Oronoque Lane. This is due to the elevation at the intersection of Oronoque Lane and James Farm Road. They noted that at 100 and 150 Oronoque Lane, a vehicle operator exiting and attempting to make a left turn onto Oronoque Lane would not see an average sized vehicle turning onto Oronoque Lane from James Farm Road until the vehicle is well into Oronoque Lane and nearing the driveway. The fire department also offered a few comments. On the site map for 100-150 Oronoque Lane, they reference an emergency vehicle travel path utilizing an E1 non-walk and heavy rescue. That vehicle is not in their fleet. For them to identify travel path and turning radii for emergency vehicle access, they should be using their aerial device Truck 1. It is the most restrictive. Our fire chief, Jermaine Atkinson, also offered a comment. His major concern is the access for tower ladder. He's attached a turning radius, which is in your packets and in the packet online. and it shows the reach needed to set the apparatus up for access in the event of fire. From the preliminary drawing, the center buildings may need adjustment, and he would also recommend to have 2 fire hydrants installed in the center of the development for fire protection. This proposal is inconsistent with several of the POCD objectives and policies, including Land Use Objective 2, Actions 3 and 12, to promote high-density developments in areas adequately served by transit and community services, to preserve and protect environmental sensitive areas and critical habitat by strictly regulating development in these areas and utilizing low-impact development strategies, as well as Housing Objective 3 in action, which is Objective 3, Action 4, consider discouraging multifamily housing in established single-family neighborhoods not near transit stations or bus lines. Conservation, Open Space, and Recreation, Objective 7, Action 2, support the efforts of conservation organizations to manage the land for invasive species, habitat diversity, critical habitats, and listed species, as well as to continue to work collaboratively with residents, neighborhood groups, and other stakeholders to address open space or environmental needs, as well as the Energy, Environment, and Sustainable Objective 4, Action 2, encourage low-impact developments, educate the health and environmental impacts of large-scale development proposals. Mobility, Objective 4, Action 1, continue to promote transit-oriented projects in the TUD overlay zone. In conclusion, this proposal is inconsistent with several objectives of the POCD, as previously discussed. Also, there are no public sewers allowed in the proposed project areas. Both properties are currently served by septic systems. Therefore, a high-density multifamily development is not recommended for the proposed locations.
Thank you. Does anybody on the commission have any questions for or discussion about this?
One observation, so Smith, am I correct that there are 34 parking spaces for these 34 units?
These are 32 townhomes, and I think, yes, the parking standard is 1 for 1, but maybe, like, I don't have the exact zoning text amendment here. The important part to note is that there is no sewers. It's in a sewer exclusion zone.
There's also garages, so they have a garage and then a parking space in front of the garage. Does anyone else have any questions or discussion? And just as a reminder, we're giving a favorable or unfavorable recommendation back to zoning. Questions or discussion? Okay, does anyone have a motion for this?
Yes, I'd like to make an unfavorable recommendation back to the zoning board because this is inconsistent with our POCD, specifically the objectives for land use, housing, conservation, open space and recreation, energy, environment, and sustainability and mobility. It also raises a number of safety, environmental, and health concerns as outlined by our staff. And while the town of Stratford appreciates the need for affordable housing, this just isn't consistent with their plan.
Any second?
Second.
All in favor?
Aye.
Thank you. Okay, passes unanimously. Or, yes, the motion was unanimous. Okay, so the next one is 2803 Broadbridge Ave and 0 Broadbridge Ave. If you could please summarize this.
So the 2803 and 0 Broadbridge site includes a single-family home with 1,386 square feet of living area and a 480 square foot garage situated on a combined 1.57 acres. The applicant is proposing a change of zone for these properties from an RS4 district, which is residential single-family, to a RM1 district, which is residential multifamily, with the intention of subsequently applying for a subdivision of the properties to construct 2 or 3-family townhouse-style residential units. The RS4 zoning district currently allows for the development of single-family homes on lots of at least 7,500 square feet area with a maximum impervious coverage of 50%, building height of 30 feet, and building coverage of 25%. Comparatively, the RM1 zoning district allows for the development of attached 2- and 3-family homes on lots of at least 7,500 square feet with a maximum impervious coverage of 66.66, building height of 30 feet, and building coverage of 33.33. The subject parcels are both situated predominantly on farmland soils and are within 200 feet of wetland soils. The proposed zone change map submitted by the applicant incorrectly depicts the existing lots west of 2803 Broadbridge Ave, which the properties are 2775 and 2777 Broadbridge Ave. While the applicant's lot survey and proposed zoning change map both reference the plot plan showing duplex housing, lot B map 2296, on file as RM 2346, the properties depicted on map 2346 do not appear on the applicant's survey or map. The applicant should submit a revised lot survey and proposed zone change map to accurately depict the zone boundaries of the adjacent properties. The applicant also requested a pre-application review with the Planning and Zoning Administrator, Susmitha, on August 28th, 2025. On September 11th, Ms. Atoda emailed the applicant a preliminary land use and zoning analysis based on the materials shared with her at the time. The preliminary analysis concluded that the creation of a 7-lot subdivision to build townhomes was inconsistent with the future land use map of the POCD, which recommends medium-density residential uses at this location. And the preliminary subdivision map is in your packet. There were a few comments from town staff, including one from the town engineer. He noted that the Stratford WPCA approval would be needed for this type of development. There is a known sewer capacity issue downstream on Broadbridge Ave, so the impact of additional sewer flows needs to be evaluated. He also noted that the existing contours seem to show a depression on site, which would collect and store runoff in existing conditions. Therefore, the proposed conditions would need to take this into consideration in comparing the existing versus proposed flows for MS4 and peak flow evaluation. There are drainage issues downstream in the Marina, Albert, Bruce Brook area, so the 100-year storm should be the design storm. There is no information in the submittal regarding the development or mitigation of stormwater flows. Additionally, site development is required to be performed in accordance with the state stormwater quality manual as usual. The town health department also provided comments, given that the year the existing single-family home was constructed, similarly to a previous application, the EPA certified firm would need to be a part of the disturbance of any paint because of lead exposure. The fire department, Fire Chief Jermaine Atkinson also provided comment stating no major concerns with the exception of the driveway length for the rear plot. If there is an access road or access needed to get there, it would just need to be wide enough and able to accept the weight of a pumper weighing roughly 44,000 pounds. There was a typo in the staff report, but it is 44,000. The access for the aerial ladder is also a consideration for this in the event of a fire. In terms of consistency with the POCD, the proposed zone change to RM1 is inconsistent with the future land use plan, in the current POCD. The subject properties are within the medium density residential land use category, which, as we've said multiple times tonight, it is 2 to 4 dwelling units per acre, with community services being essential to this future land use. The current RM1 zoning regulations our current zoning regulations allow for higher density residential development, which is inconsistent with the future land use map. The surrounding area also has limited community services, including transportation. With that being said, the property is on Route 15 of the Greater Bridgeport Transit system, with connections to Bridgeport every hour, but limited connections within Stratford without having to go out of Stratford and then come back in. The Greater Bridgeport Transit bus stop, approximate to the subject property, currently does not have any bus shelter, and it is poorly maintained and difficult to access safely. There is a lack of sidewalks, overgrown trees, and minimal space between the road and the stop. In conclusion, the proposal is inconsistent with several objectives of the policies of the POCD, including the Housing Objective 3, Action 4, considering discouraging multifamily housing in established single-family neighborhoods not near transit stations or bus lines. Mobility Objective 4, Action 1, continue to promote transit-oriented development projects in the TOD overlay zone, and community facilities, infrastructure, and utilities. Objective 2, Action 1, require that new development must manage all stormwater on site and encourage low-impact development.
Thank you. Does anyone have any comments or discussion about this topic?
A quick question. Is this anywhere near an RM1 zone? Is there an RM1 zone close by?
I think to the south of it, like, this is not a colored map, but if I can go on the Stratford GIS, I can tell you very clearly. It is closer to RM1 zone, but this is in single family and the future land use map. So when it comes to Planning Commission review, in fact, when it comes to zone changes, there is a two-pronged test that you have to, pass according to Connecticut General Statutes, Section 8-2. One is its consistency with the plan of conservation and development, and second is it has to meet the set of requirements that are provided in the Connecticut General Statutes for zone changes, like impacts to traffic, drainage, infrastructure, and all those things. So if you look up the statute, you will know. So your job tonight is to analyze it based on the future land use map only. So if the future land use map is saying something, you cannot, you don't have more discretion there to deviate from the future land use map unless the POCD itself gets amended.
Thank you. Any other questions or discussion? Were you still looking something up for us?
I'm just looking at the map because he asked me this question, and I did find the map here. Let me just put the layer on for you. So I wish I can show you right away where. So this is, I think, I can't show it. The layers aren't turning off, but it's right next to it. But it's also like I said, your job is to look at the POCD and consistency with the POCD.
Thank you. Okay. Any other questions? Can I get a motion? And remember, it's favorable or unfavorable. Go ahead. Okay, sorry. Try turning your, can you turn your mic off?
I recommend I move an unfavorable recommendation as inconsistent with the housing and mobility objectives of the POCD and also concerns about stormwater.
I think you should repeat as it is inconsistent with the future land use map of the POCD.
Yes.
Yes.
Yes, okay. Any second to that? Claire, thank you. All in favor?
Aye.
Aye. Okay, thank you. All right. Next. The next one is an 824 review referral, 993 Honey Spot Road and 0 Mayfair Place. Can you please summarize this?
Yes, so the 993 Honey Spot Road and Mayfair Place site includes a commercial building with 13,206 square feet of living area, situated on a combined 1.32 acres. The current tenant is 993 Honey Spot Road LLC, and they are interested in purchasing the property from the town. The town of Stratford acquired this property in 2012 as a result of a foreclosure for non-payment of taxes. And it was previously owned by PDC Realty Company. After acquiring the property, the town did some investigation and environmental assessments, which revealed that there were previous assessments done in 1994 that found high levels of polychlorinated biphenyls, which are commonly known as PCBs, which are a group of human-made chemicals commonly used in industrial and commercial products. They found this in several test wells, and the property owner at the time was notified, but it was not remediated. In 2000, CTD brought an enforcement action against the property owners, but again, nothing came of it. No proof of compliance was found by the town when they were doing their investigations. Because of the presence of PCBs, the property does qualify for the Transfer Act, and upon other investigations, they found other contaminants on the property. Due to the extensive remediation required because of these contaminants and the poor physical condition of the building on the property at the time of acquisition by the town, they agreed to lease the property to the tenant. under the condition that the tenant would pay an amount approximate to the taxes that the town would have received, and that the tenant would make significant capital improvements in exchange for the option to purchase the property as is, which is why this is coming to you now. The tenant has since made these structural improvements and requested to purchase a property, which would make the tenant responsible for any environmental reporting to CTD and for remediation of the property. The property is located in a light industrial MA zone. It is occupied by a building, like I said, in a parking lot, with the current business on site being R&M Custom Contractors. The property is in a flood zone and is nearby two major thoroughfares. It is surrounded by other light industrial uses as well. Some of you who did have the packet tonight, I have made a correction, but for those of you that picked it up, your packet will have an additional comment that I redacted after more investigation with our zoning enforcement officer today. So upon conducting a site visit, it was found that R&M Custom Contractors are using a portion of the property as a contract storage yard for vehicles and road salt, but this was approved, and they have the permits for it prior to regulations that would have changed that. So there were a few comments from town staff. Conservation Superintendent Kelly Kerrigan asked about remediation, whether it would be a condition of the sale. It will be. And the town health department also noted that they advised that the prospective buyer be made familiar with the environmental history, extent of contamination of the subject properties, and the site status with the Property Transfer Act. The prospective buyer should understand their responsibility to conduct further site assessment and refer back to the memo, which is in your packet. They also asked to be notified in advance of any future site environmental remediation activities. The POCD offers the following guidance on the energy, environment, and sustainability chapter. The goal is to ensure that Stratford is a sustainable and thriving community that benefits from and supports clean energy, preserves and cares for its ecosystems, prioritizes environmental cleanup and protection. And so in our objective 4 of this goal, we have promote stewardship of the town's fragile natural environment, such as wetlands, watercourses, plant and animal habitats, and other environmentally sensitive areas. And action 3 is to prioritize the remediation and reuse of brownfield properties. Therefore, the proposal is consistent with the goals and objectives of the POCD, specifically with regards to this goal, objective, and action. Additionally, the town council should consider requiring remediation with the reverter clause in the contract or entering into a state cleanup program as a condition of the sale to ensure that the site will be remediated once sold, per the conservation superintendent's comments. And furthermore, the health department's comments regarding prospective buyers' knowledge of the property's environmental history and responsibility to conduct further site assessment and environmental remediation should be duly considered.
Thank you. Does anyone have any comments or discussion on this topic?
Yes. The tenant seems to have made substantial improvements to the property. My question is whether there's, how the price is determined and whether there's a survey to see if anybody else is interested in it, or just this one property owner, or how does that work?
I believe one of the original memos that the town attorney provided was that at the time that the lease agreement was set up, that the leasee would be allowed to purchase the property for, I believe it was $45,000, which was predetermined at that time. But what was your second question? I'm sorry.
Thank you.
Any other questions? Discussion? Okay. And is this approval not favorable, right? Favorable recommend, favorable, right. But this is favorable and favorable back to town council. Does someone have a motion?
I move a favorable recommendation.
May you also add that...
The conditions.
No, include the considerations recommended in the staff report, along with the favorable.
I move a favorable recommendation with consideration of the recommendations in the staff report.
Second? All in favor?
Aye.
Aye. All right, thanks, guys. Now we have a bond release request for 630 James Farm Road. Can you summarize this? Because I don't think that we got any
Yes.
paperwork on it.
So, I would like to make a recommendation to table this to the next meeting, or it is up to you, or a conditional approval on the submittal of a letter signed and sealed from the surveyor, as well as approvals from the conservation superintendent. I did leave an email regarding this matter from the town engineer. We were waiting to get additional documentation from the town engineer, but unfortunately, there were a few things that the applicant did not provide, and so we believe that they will be provided soon, but we cannot move forward until we get them.
Okay. And this isn't time sensitive if we were to table it? Okay, because I think in the past it happened. Does anyone have a question about this? This is really kind of straightforward. Okay, can I get a motion? And is this favorable? No, we're tabling it.
I'd like to make a motion.
Either to table or to for conditional approval upon receipt of the items listed in the email.
I'd like to make a motion to table the bond release request from 630 James Farm Road.
Second.
Thank you. All in favor? Thank you. Okay, we have one more thing. Did you all get the yearly schedule for meetings for 2026? Can I get a motion to approve the meeting schedule?
Sorry. So we sent an email, Stephanie sent it to the Planning Commission, I sent it to the Zoning Commission because one of the zoning commissioners requested a time change, but looks like it may not be possible because of multiple moving parts to this. First is that we need the council chambers to be available for us on the dates that we want, and then some members can make it, some members are part of different commissions that they have to attend, so they're requesting other days, and those days kind of coincide with other meetings. So at this time, because of the complexity of scheduling associated with changing the days that are fixed for these commissions, we just go ahead with whatever we have shared with you.
These are Tuesdays still?
Yes, these are just Tuesdays.
Tuesdays at 6:30 as
Yeah.
they are now. Okay. Can I get a motion to approve this schedule?
Motion to approve.
Second?
Second.
All in favor?
Aye.
Aye. Thank you. Last but not least, can I get a motion for adjournment at 8:23 PM?
Motion to adjourn.
Thank you. Second.
Second.
All in favor?
Aye.
Thank you. Okay, so we're meeting on Tuesday, December 16th.